All right. Good morning, everybody, and welcome to the Senate Law and Justice Committee. We're going to go ahead and get started. We have two gubernatorial appointments to consider first. We'll begin with Senate Gubernatorial Appointment 9209. And Judge Rogoff, if you could come forward. And don't get comfortable. Senate Rule 69 requires that your testimony before this committee be under oath or affirmation. Please raise your right hand. Do you swear or affirm that your testimony and documents presented to this committee are truthful?
Yes.
Okay. Please be seated.
Now I get comfortable.
Now you can get comfortable. Right. Although hopefully we won't keep you for super long. So welcome to the committee, and thank you for making the time to come down here and be before us. I wonder if you could start by just giving us some of your background and the interest that drew you to the work on the commission.
Sure. Well, first of all, my name is Roger Rogoff. I'm a King County Superior Court judge in King County. I'm currently on the criminal calendar, have been in juvenile court for the last 3 years. I am married with 2 girls. And as I said the first time I was here, I think that having 2 kids makes crime and punishment a big part of your life. And so I deal with that every day. And then in work, the SRA has been a huge part of my career. For 25 years, I was a prosecutor and for a short period of time, a defense attorney. So I've been working with the SRA my entire working life. And I know the ins and outs of it, what's good about it and what's bad about it. And I've enjoyed the last couple of years working with the Sentencing Guidelines Commission, trying to make it better.
Could you give us your view about how the work that the legislature charged the commission with is going and how that process is feeling?
Sure. Well, I think the Sentencing Guidelines Commission is an interesting place. You've asked us to review the guidelines, review sentencing in Washington, and make recommendations to the legislature. We also are a broad group with lots of different voices, and so it is a difficult place to find consensus, but I don't know that that's always what it's about at the Sentencing Guidelines Commission. Our job is to be the experts for you, people who work with the guidelines on a daily basis or people who are affected by the guidelines on a daily basis, and we try to give as much expertise to you as possible so that you can make good decisions.
Do you feel like you're going to have useful feedback for us as a result of the study?
We have started that process, and I know that some of you have gotten some at least preliminary recommendations that are coming out of our commission, to at least 2 different recommendations. Perhaps there'll be more, and we look forward to talking about it. I think there's some exciting ideas about giving judges more discretion that are coming out of the Guidelines Commission, letting judges make decisions based on the people that are in front of them at the time of sentencing, not being hemmed in by 12 plus to 14 months and not being able to do anything about it. So those are some of the things that we're working on, and it's been great work.
Great. Do other members have questions? Senator Patton? Okay. Looks like you're off the hook for today. We plan to consider your appointment on Thursday in executive session. So thank you very much for coming forward, and we'll try to get this moved along so that you can be official.
Thank you all. Have a great morning.
Okay. Thank you very much. That'll conclude our public hearing on Senate Gubernatorial Appointment number 9209. We'll move to a public hearing on Senate Gubernatorial Appointment number 9182. And Judge Hauser, if you could come forward. All right. Oh, boy, you're all ready. Senate Rule 69 requires that your testimony before this committee be under oath or affirmation. Please raise your right hand. Do you swear or affirm that your testimony and documents presented to this committee are truthful?
Yes, I do.
Okay. Thank you very much. Welcome. Thank you for making the journey here to be with
thank
us.
you.
So same questions for you. Could you start out by just giving us a little bit of your background and what drew you to this work?
Well, I've been a lawyer since 1983, Oregon for 20 years, and moving to Washington. And in 2003, became a lawyer here. During that time I was a lawyer, I primarily was either a prosecutor or a defense attorney. in the state of Washington. Most recently, prior to my appointment to the bench, I was a member of the Public Defender's Office in Kitsap County. I've been a Kitsap County Superior Court judge since 2014. So that's my basic background. My practice area has been criminal law primarily for most of the 31 years that I practiced law.
And can you talk to us about your experience on the commission so far?
I started with the commission just this last year, and so I came in mid-flow, as you would, in some of the things that we do. The things that really we've been concentrating on while I've been part of the commission or meeting with the commission is the sentencing guidelines reform that you asked us to do in the last session. And I can echo a lot of what Judge Rogoff said. I think that we have been able to present as commission and the different work groups things that are going to be an interesting change that you can consider when we present that. I think that we're well on our way to getting that to you. We're I think, on target to getting it to you.
By your extended deadline?
Yes. I believe so. But we've been in some pretty significant discussions on all of those things. And there is a broad group of people and a lot of stakeholders at the table, and they have a lot of different ideas. And so hopefully over the next couple of months, we're going to be able to nail some of those down for either maybe a majority and minority position or just a couple of different options that you'll have.
Okay. Do other members have questions for Judge Hauser? Okay. Looks like that was pretty easy for you too. Sorry to make you drive all the way over here for this, but hopefully it'll pay off in the end.
Thank you.
All right. Thank you very much. That'll conclude our public hearing on Senate gubernatorial appointment number 9182. The Madam Vice Chair is going to have to leave us a little bit early today, so we are going to start out with the public hearing on Senate Bill 5205. And Melissa, if I could ask you to jump in and give us a briefing on that bill, that would be great.
Good morning, Chair Peterson and members of the committee. Melissa Burke-Kane from your committee staff. Before you is Senate Bill 5205. It concerns provisions governing firearms possession for persons who have been found incompetent to stand trial and who have a history of one or more violent acts. This is very similar to a bill that you heard in this committee last year. And by way of background, under current law, the involuntary commitment of criminal defendant works something like this. A criminal defendant may be involuntarily committed for mental health treatment and placed in a facility for treatment related to a competency evaluation, competency restoration, or criminal insanity. An involuntary civil commitment can also occur directly following dismissal of criminal charges based on the criminal defendant's incompetency to stand trial. A defendant who is found incompetent only loses their firearms rights if the person is committed to an inpatient facility. A criminal defendant is incompetent to stand trial when due to a mental disorder, the defendant lacks the capacity to understand the nature of the criminal proceedings or lacks the ability to rationally assist in their defense. Whenever there's reason to doubt the defendant's competency, the court delays further criminal proceedings to allow for a competency evaluation. If the court determines after an evaluation that the defendant is incompetent, a period of competency restoration treatment is permitted to restore the defendant to competency in all felony cases and in all non-felony cases which are classified as serious offenses. State law allows a number of options for competency restoration treatment, including treatment in state hospital or another secure facility or in an outpatient setting. If the case is non-felony, the maximum in-custody restoration period is 14 days, in addition to any unused time of the competency evaluation period. The court may alternatively order the defendant to be, if the court decides or if the parties agree the person is unlikely to regain competency, the court may dismiss the charges without ordering the defendant to undergo competency restoration treatment. After dismissal, if the non-felony charges are serious, the person is detained, sent to an evaluation and treatment facility for up to 72 hours for evaluation under the Involuntary Treatment Act. If the charges are not serious, the court must order an evaluation of the defendant by a designated crisis responder for possible commitment. If the designated crisis responder detains the defendant, then the person may lose their firearms rights again at the end of 72 hours when the evaluation and treatment facility files a judicial process, a 14-day commitment petition. If the designated crisis responder does not detain the person, or having been detained, the person is released at the end of the 72-hour detention period without a judicial commitment order, the person is under current law released without losing their firearms rights. If this bill is enacted, if the court finds that a defendant is incompetent to stand trial and dismisses non-felony charges without committing the defendant for treatment, the court must make a finding whether the defendant has a history of one or more violent acts. If the court finds a history of one or more violent acts, the person is barred from possessing a firearm until a court restores their right to possess a firearm. And the court must order and notify the person both verbally and in writing of their loss of firearms rights. The bar remains in effect until a court restores their defendant's right to possess a firearm. And the additional thing that is different from last year is that this bill adds additional violations of the crime of second-degree unlawful possession of a firearm for violating either a restraining order under the Parentage Act or violating an order barring firearm possession after dismissal of non-felony charges based on incompetency. Unlawful possession of a firearm in the second degree is a Class C felony. And with that, I'd be happy to answer any questions.
Thank you very much. Do we have questions? Senator Patton.
I just want to see if I understand this right. Under the one section, we're taking discretion away from judges to make this decision, and somebody that had substantially damaged some property could have their Second Amendment rights compromised or taken away from them, and there's no discretion.
Well, the judge has to make a finding regarding the risk of violence, but I couldn't say necessarily that the court loses its discretion. It's still a case-by-case decision based on what the judge finds in court and what the evidence is that's presented.
Okay, so it doesn't necessarily prohibit a person who has one violent offense from possessing a firearm?
Well, I'm looking at Senator Dinker because she's an expert in this area and I am not. Okay. So perhaps she might be able to respond more efficiently than I.
I'm happy to.
And yeah, maybe we'll just have the prime sponsor speak, and then if we have questions. Okay, Senator Dingram.
Thank you, Chair Peterson, for hearing this bill. So years ago, our restoration statute basically said that if you're charged with a crime and if you have a history of violence, you are eligible to go for restoration services at Western State Hospital. And so restoration services was related to your history of violence. Years ago, the legislature decided to change that and have restoration services be linked to the current charge. As a result of that, what fell out were these individuals who have been charged with a crime, found to be not competent, who have a history of violence. They are no longer going for restoration services. And because the loss of firearm was linked to the commitment, they are now basically released from jail out on the street. And so this is trying to close that loophole to say we have to be very strategic about looking at individuals who have a risk, who have a history of violence. So this is about charged with a crime, found to be not competent with a history of violence in a court. The judge will make a finding that if you have a history of violence, you will lose your right to possess a firearm. And does that help, Senator Patton? Or?
That helps. Has there always been in the substantial property damage as being a violent act? It seems kind of in a different category as the others.
It would be something that the prosecutor would have to prove to the court. So if the judge concluded based on the facts that whatever conduct occurred is a violent act, then that would classify them as losing their firearm. You know, but it depends on what the actual facts are, but it is a fact-based scenario. I'm happy to answer any other questions.
Any other
It is a bill that is specifically targeted to address a very specific population, and this need exists because of a change that was done years ago to our restoration bills. And I'm hoping to close that loophole, and I would love to have your support for this bill. Thank you.
Okay. Thank you very much. Seeing no other questions for the prime sponsor, we'll move to public testimony. Let's bring up Ben Carr, Tom Duhamel, and Colin English. Please proceed.
Thank you. My name is Dr. Tom Duhamel. I'm a licensed clinical psychologist, and I live in Seattle's 46th Legislative District. I'm here today to testify in support of Senate Bill 5205. State law defines a violent act as a behavior which results in or could have resulted in death, bodily injury, physical pain, or substantial damage to property. The aim of SB 5205 is to prevent acts of gun violence by restricting the possession of guns by people whose mental competency has been questioned in court. The procedure for determining a person's competency to participate in their own defense begins in the courtroom. At any time during a trial, upon witnessing a behavior suggestive of incompetency, a judge may make a referral for an evaluation by a forensic mental health specialist requesting answers to the following questions. Does the defendant have the ability to understand why they are in court? Does the defendant understand the court's actions as it relates to them? Does the defendant understand the possible consequences they may face? Does the defendant have the ability to communicate with their attorney in their defense? If, after an extensive evaluation, the mental health specialist concludes that the defendant is not competent to stand trial, the presiding judge will usually make a referral for treatment before allowing the trial to proceed. It is my personal and professional opinion that a person who possesses a gun, who is incompetent to stand trial, and who has already committed one violent act, presents a high risk for committing another violent act. It is also my professional opinion that this person should be barred from possessing a gun until their evaluation and subsequent treatment is complete and until the court has decided to restore their right to possess a gun. Please vote yes on Senate Bill 5205.
Thank you very much. Please proceed.
Good morning. My name is Ben Carr. I'm a King County Deputy Prosecuting Attorney. I speak today in my own capacity, but I'm also here speaking as somebody who has spent the last 10 years in criminal prosecution, who has seen countless cases in which dangerous or mentally deficient folks have...
You might pull the microphone just a little bit closer to you. Thank you.
Thank you, Senator. I've seen years of cases where dangerous or mentally deficient folks have gotten their hands on guns, and I speak personally as somebody who lost a parent to gun violence at the hands of someone suffering some mental issues who should never have had a gun. I speak today in support of SB 5205. It is a common sense bill. It does not strip firearm rights from reasonable and responsible gun owners. It closes one of these loopholes that we in the criminal justice system have seen pop up from time to time. It recognizes that closing this loophole is a public safety issue, and I think this panel, this body recognizes that the electorate wants to see such loopholes closed. So if there's a finding of incompetency to stand trial in combination with a finding that a defendant has a history of one or more acts of violence, then the court can revoke that person's firearm rights. As Senator Dingler pointed out, we already do something similar in cases where folks are found not guilty by reason of insanity, or folks are ITA'd, involuntarily committed for a certain period of time. And we already do something similar for when folks are found incompetent on felony offenses and what we call serious offenses. Those largely deal with domestic violence, stalking, things like that. So what this does is it allows a court to be a bit more holistic in its determination. It's not hamstrung anymore by the precise title of the charge. It allows the court to note someone's present mental defect and their prior acts of violence, and to realize that that combination means that the gun in hands of such a person would present a public safety risk. And that's really a common sense solution. So I do believe that this bill balances the rights of reasonable and responsible gun owners with the rights of individuals and communities to stay safe, and I urge you to support it.
Thank you very much. Senator Patton has a question.
I wasn't quite sure what you're doing now for the King County prosecutor. You're handling these type of cases right now, or you have some other assignment?
Sure. In my work as with the prosecutor's office, I've had a number of different roles, including homicide and violent crime. More recently, I've been in juvenile court, so dealing with youth who get a hold of guns. But I have had rotations in domestic violence and other mainstream felonies, including gun possession.
Just to be clear, King County Prosecutor Dan Satterberg is not taking a position on this bill? Is that what you're saying?
Right. I am not here as a formal emissary from my office. I'm here in my own personal capacity.
Okay, thank you.
Okay, thank you very much. Please proceed.
Good morning. My name is Colin English, and I live in District 36. I'm here today because, like far too many families in our state, mine has been forever changed by gun violence. This month marked the second anniversary of an event that forever altered the life of my wife and our family. While chaperoning our 12-year-old son to an all-ages show in Seattle, my wife was shot by a high-capacity assault rifle used in a drive-by shooting. We consider ourselves lucky that my wife survived after 2 surgeries and that our son was on the other side of the building when she was shot. We are not so lucky with our son's exposure to the aftermath and chaos of the shooting, including witnessing his mother fighting for her life as she lay in a pool of her own blood. Experiencing the shattering effect of gun violence firsthand has compelled me to speak out on behalf of all victims of gun violence. That's why I'm asking you to support Senate Bill 5205, which would close a dangerous loophole in our current law that allows people who have been found incompetent to stand trial to have access to firearms, even if they have a history of violence. Keeping guns out of the hands of people with a proven history of violence just makes sense. This isn't a partisan issue. Washingtonians from every corner of the state have shown that they support laws to help prevent guns from falling into dangerous hands. This bill would help do just that, and it would help reduce gun violence in Washington. Thank you for your time.
Thank you very much. Are there any other questions for this panel? All right. Thank you all for coming forward. Next, we'll bring up Eric Piskonski, Jordan Waits, and Raymond Miller. That's all right. All right, please proceed.
Good morning, Mr. Chair, honorable committee members. Thank you for hearing testimony on this bill. My name is Jordan Waits. I'm a former Marine. I'm a student. I'm a constituent of the 29th District, and I am an owner of several firearms. Last year, I had the opportunity to work on 1639 because I believe it was my responsibility to do so with all of the violence our community is facing. And something that can help close the loopholes in that violence is Senate Bill 5205. I think this is really important to do because it puts people who have a predisposition of using violence as a resource to cause conflict or to solve conflict from being able to take somebody's life. And our most valuable resource in protecting our community is the preservation of human life. By doing this, we're going to put ourselves in a position where people who are not mentally competent to stand trial are not going to have access to a weapon that will be able to take a human life with 2 pounds of pressure. I ask you to support this bill. I ask you to help close those loopholes to keep our communities safe. And I ask that you give our justice system the tools it needs to keep victims safe first. Thank you very much for hearing this testimony.
Thank you very much. Please proceed.
Good morning, Mr. Chair, committee members. My name is Raymond Miller. I live in Marysville, Washington with my wife, Jennifer. I'm a U.S. Air Force veteran, a clinical therapist, and a veterans advocate. I have spent much of my life working with combat veterans, people who are in crisis, most of them suffering from post-traumatic stress disorder. I also live about 3 miles from Marysville Pilchuck High School campus, where in 2014 we had the tragic shooting of 4 young people and the suicide death of the shooter. In Washington State, someone is killed by a gun every 14 hours. In recent years, we have made tremendous progress in the fight against gun violence, expanding background checks and closing the private sale loophole with Initiative 594, establishing extreme risk protections orders with initiatives of 1491, and strengthening the standards for purchasing semi-automatic assault rifles, extending comprehensive background check to semi-automatic assault rifles with Initiative 1639. Each of these measures was supported by a large majority of Washington voters at the ballot. Time and again, voters have shown that they support responsible measures to help keep guns out of dangerous hands. The bill you have now in one of those measures, it would close a dangerous loophole that allows someone who has been found incompetent to stand trial and who has a history of violence to possess a firearm. Individuals deemed incompetent to stand trial often suffer from serious mental illness. We know mental illness does not mean that the individual automatically poses a threat to themselves or others, but someone found incompetent to stand trial who has a history of violence possesses a higher risk to commit further violent acts. Securing guns from these individuals while they undergo treatment and until a court restores their right to possess a firearm just makes sense. It can help prevent suicide and further gun violence. I strongly urge you to support Senate Bill 5205. Thank you.
Thank you very much. Please proceed.
Thank you, Mr. Chairman and the committee. Sergeant Eric Paskonsky with the Seattle Police Department. I run our crisis response unit. It's good to see you all again. I just want to cover a few quick points here. So life safety is the most important tenet for law enforcement, and finding ways to prevent gun violence is an imperative. One of the most effective ways to achieve that goal is by limiting access to firearms for those individuals identified as more likely to cause harm. As we have seen with the ERPOs, providing a mechanism to remove an individual's access to firearms when they present a threat to themselves or others is an important piece of ensuring public safety. Extreme risk protection orders have allowed us to intervene in dangerous situations and remove the threat of firearms, making things safer for the individual, their community, and law enforcement. We must balance an individual's constitutional rights with the risks presented to themselves or public safety, all the while ensuring there is no perception of criminalizing mental health issues. One of the gaps we have seen in the criminal justice system is the issue of competency and then subsequent ongoing behavior. Those individuals deemed to be not competent and also have a history of violent acts present the highest risk of future violent acts to the public and themselves. This proposed legislation would provide a tool for the courts to restrict access to firearms of those individuals found to be not competent and have a history of one or more violent acts. Thank you for your time.
Thank you very much. Do we have any questions for this panel? Thank you very much. Looks like you're off the hook. That'll conclude our public hearing on Senate Bill 5205. We'll move back up to the top of the agenda and begin to consider Senate Bill 5181. And Melissa, if you could give us a briefing on that bill.
Good morning again. Melissa Perkane from your committee staff, and before you is Senate Bill 5181. This is a bill that you did hear last year in this committee, and it would prohibit a person who is detained for a 72-hour hold under the Involuntary Treatment Act from possessing a firearm for a period of 6 months. By way of background, in general terms, the Involuntary Treatment Act can be triggered when a designated crisis responder finds a person has a mental disorder or a substance use disorder, and because of the disorder, the person presents a likelihood of serious harm or is gravely disabled. In those cases, the Involuntary Treatment Act, the ITA, authorizes civil commitment. Two other ITA requirements are that the person will not voluntarily cooperate with treatment, and there is no less restrictive alternative available that will meet health and safety needs. Likelihood of serious harm means a substantial risk that the person will harm themselves or another person or another person's property. The ITA process generally begins when a person is detained for investigation for civil commitment for up to 12 hours. If the designated crisis responder finds a basis for commitment, they may detain the person for up to 72 hours in an evaluation and treatment facility, or if that is not available, a single bed certification facility. And if neither is available, the person cannot be detained. During the 72-hour detention period, the facility providing detention may file a court petition to authorize an additional 14 days of involuntary treatment. And at this point, the law provides the person with a court hearing, legal counsel, the right to present evidence, and the right to confront witnesses. If detention continues past this stage, further court petitions may be filed at 90 days and 180 days of involuntary treatment. Under current law, person can lose firearm rights upon judicial commitment in two ways. A person who is judicially committed under the Involuntary Treatment Act loses their right to possess a firearm under state and federal law. Judicial commitment happens at that 14-day, a 90-day, 180-day stages of the Involuntary Treatment Act. Judicial commitment can also occur when a person who is a criminal defendant is placed in a facility for treatment related to criminal insanity or restoration of competency to stand trial, which is what we were discussing in the bill just heard. State law authorizes a person prohibited from possessing a firearm to petition the Superior Court for restoration of their firearms rights. For a person whose prohibition comes from involuntary commitment, the person must petition the Superior Court that ordered the involuntary commitment, and the person prohibited from possession must establish by a preponderance of the evidence that they are no longer required to participate in court-ordered inpatient or outpatient treatment. The person has successfully managed the mental health condition that is related to the commitment. Person no longer presents a substantial danger to oneself or to the public, and the symptoms related to the commitment are not reasonably likely to recur. If enacted, this bill would establish that a person detained under the Involuntary Treatment Act for 72 hours on the grounds that the person presents a likelihood of serious harm, but is not detained for a 14-day judicial commitment may not possess a firearm for 6 months after the date of detention. The designated crisis responder must inform the person of the 6 months prohibition, both orally and in writing, before the discharge. The person must surrender any concealed pistol license and any firearms they possess or control to the sheriff or the chief of police where the person lives. The person's right to possess a firearm is restored automatically at the end of the 6-month period, and any surrendered firearms must be returned to them. The person may petition the court to restore their rights to possess a firearm sooner than the 6-month period by following the restoration process that is provided under the law. And with that, I'd be happy to answer any questions.
Thank you. Senator Solomon has a question.
I'm just wondering if there's going to be a constitutional problem with this bill in terms of an insufficient nexus between the 72-hour hold and the finding of danger, or I mean, this is automatic, but I think there has to be some kind of greater indication. I'm not sure that this bill has that. So do you have any thoughts on that?
The thought that I have on that is that whether or not there's a constitutional problem is really something that the courts would have to decide. And it sounds like what you're describing might be an as-applied challenge to the law, and that would be something that would be fact-specific. There are some cases on similar laws, and I know that we have a representative of the Attorney General's office that can speak more directly to those cases, but I can tell you that at least in California, a similar law that would have prohibited possession of firearms for up to 5 years was upheld as being constitutional under due process grounds. Of course, we could never predict and would not try to predict what the courts would do here.
Okay. Any other questions for staff? All right. The gentlelady from the 48th District. Senator Cooter, what do you have to say about your bill?
Thank you, Mr. Chair and members of the committee. Thank you, Melissa, for another excellent recitation of the bill. I'm not going to belabor everything that she just said. I will start by saying that this legislation is intended to save lives, and specifically, it's intended to reduce suicide by gun. over half or nearly half of the suicide deaths in Washington are committed with a gun. And I can tell you from personal experience with a cousin who, in a state of despair, reached for a gun and ended his life. I can tell you that if he had 6 months to think about it, he would likely be here today. And one thing I can tell you for certain is his 12-year-old daughter would not have found him with a bullet hole to the head. And there are ripple effects from this violence that we see, not just the loss of someone that you love, but the ripple effects for those who are left behind. And this is what this bill is designed to do. And I think that when someone is brought in on a 72-hour involuntary hold because they are exhibiting signs that they are a danger to themselves or others, and they're not seeing that giving them that opportunity to have a cool down period or allowing the family time to get an extreme risk protection order is just a common sense approach. And there is, at the end of 6 months, there are no questions asked and the weapons are returned. It's a temporary removal of access to their weapons. And I think in light of the number of people who commit suicide that's going up, by the way, and the fact that a gun, you don't get very many do-overs when you use a gun, that this bill is particularly important, and I urge the committee's support. Thank you, Mr. Chair.
Thank you very much. Any questions for the prime sponsor? All right, well, hearing none, we will move directly into public testimony. We'll bring up Ray Miller, Bo Jackson, and Leanne Kennedy first.
Good morning. My name is Bo Jackson and I live here in Olympia, Washington. I am a veteran from the Air Force and a former firefighter and EMT. As a member of the military, I experienced firsthand the power of guns. As an EMT and a firefighter EMT, I've seen firsthand the devastation that they can cause. That is why I'm here to speak today in support of suicide crisis prevention legislation, because in a moment of crisis, the presence of a gun can change everything in a fraction of a second. Our state has made considerable progress on this issue, but there is more we can do to keep guns out of the hands of people in crisis. Right now in Washington, only people who have been found involuntarily committed consecutively for longer than 14 days are prohibited from possessing firearms. That leaves a dangerous gap, allowing individuals who have been subject to 72-hour involuntary holds to legally purchase and possess firearms despite the potential risk they pose to themselves and others. This risk isn't just hypothetical. One study has shown that 75% of gun-eligible people who used a gun to complete suicide and 33% of those arrested for a violent gun crime had been previously subject to a 72-hour involuntary hold. This bill would help keep This bill would help keep deadly weapons out of the hands of people who want to cause harm by temporarily securing firearms from individuals subject to a 72-hour hold. By temporarily restricting firearms access for people who have been involuntarily held, we can ensure that we are doing what we can to help people make it through a mental or behavioral health crisis. I urge you to support this crisis prevention. I urge you to support the suicide prevention bill to help save lives in our state.
Thank you very much. Please proceed.
Oh, you want me to start? Yes. Okay. Thank you. Okay. Good morning. Thank you for having this hearing. And thank you to Senator Cruder for sponsoring this bill again, for telling your story. It is in the stories that we see our truth. My name is Leanne Kennedy. I'm a therapist practicing in Pierce County, and I live in the 27th. Once again, emphasis on again, I'm here to testify in support of what is really a common sense suicide prevention measure, 5181. As a therapist, I have a duty to warn if I perceive that someone is at risk of harm to self and others. I have sent clients to the emergency room. My frustration is that the laws of this state often do not support me or my colleagues in that duty. This is one example. When an individual is put on a 72-hour ITA, it's under the Involuntary Treatment Act, Involuntary is the operative word, because they are deemed at risk of harm to self, harm to others. The majority are very depressed, they are suicidal, and they are non-compliant. They are not pleasant people. Being released from a 72-hour ITA hold does not mean that they will no longer be at risk of harm to themselves or to others. There's no guarantee that that individual will follow up with the treatment recommendations or access the community services in an already overburdened mental health system. To allow such individuals access to firearms upon release defies common sense or best mental health practice. A 6-month firearm timeout is not extreme, it is not unreasonable. It creates time and space for an individual to stabilize, provides safeguards, provides opportunities for families to act. It is a humane and compassionate measure. Somewhere between 70 and 80% of our firearm deaths are suicides in this state. It is interesting to note that the most at-risk population are men over 50 in eastern Washington. To continue the status quo is just unacceptable. You can bandage a wrist from cutting, you can pump a stomach from overdosing, but you cannot undo the damage from a bullet to the brain. I believe that the state of Washington has a duty to protect those who cannot or will not protect themselves. SB 5181 is such an opportunity, such a measure, and I urge you to act.
Thank you very much. Please proceed.
Good morning again, Mr. Chair and committee members. Once again, my name is Raymond Miller, and I live in Marysville, Washington. I'm a clinical therapist, a U.S. Air Force veteran, and a veterans advocate. When we talk about gun violence in our state and in our country, we often talk about the mass shootings that devastate our community all too regularly. But alongside those national tragedies are the daily tragedies of firearm suicides, which accounts for the clear majority of gun deaths in Washington state. And veterans are disproportionately affected by suicide. In fact, in 2014, an average of 20 veterans a day died from suicide in the United States, and firearms were used in 60% of those deaths. The causes of suicides are as varied as the solutions. But research tells us that one concrete step we can take to combat this problem is to remove the threat of guns. Our current laws attempt to address this, but there are still significant holes that must be closed. For example, people who have been subject to a 4-day involuntary hold are not allowed to purchase a gun. This is a common sense protection that keeps someone in crisis from getting a lethal tool. It gives them time to get the help they need. It saves lives. But right now, there's a gap for someone who has been subject to a 72-hour involuntary hold. They're likely still in crisis, but they can go legally buy a gun. I have spent much of my career working with people in crisis. I have seen how quickly things can turn deadly when a gun is involved. If we are going to help prevent suicide in our state, we must do more to keep guns out of those people, guns out of the hands of people in crisis. Please support Senate Bill 1581. Thank you.
Thank you very much for coming forward. Do we have any questions for this panel? All right. Thank you very much for sharing your testimony this morning. We'll move to a second panel with Rebecca Faust and Eric Nelson.
Good morning. My name is Rebecca Faust, and I'm here in opposition to Senate Bill 5181. I'm concerned about allowing people who have not had their day in court to be deprived of a constitutional right, albeit only for 6 months. I think everyone should have their day in court before they're deprived of a right. I understand the concern here, but I think there should be a court process where they appear before a judge or a jury, probably a judge, either one, before their right to own a firearm is taken away. There's two processes here mentioned in Senate Bill 5181 for the 72-hour hold. A person who is detained under RCW 7105-150 or 7105-153, and I looked those up, and it looks like Section 150 is a court process, and 153 is a designated crisis responder or peace officer doing the detaining, and if I'm reading that correctly. And so my concern is with the Section 153 detentions where a designated crisis responder or peace officer is detaining someone, but they haven't appeared before a judge or a jury, and they haven't appeared before a court for that detention. And I think before we take away their right to bear arms, they should have the opportunity to appear before a judge or a jury. I think maybe alternately, there could be a process that says if they don't need treatment beyond the involuntary detention beyond the 72 days, the designated crisis responder or peace officer could petition a judge to say that they don't bear arms for 6 months, so that there's a process that lets them say, okay, maybe they only needed to be detained for 72 hours, but we can still say no guns for 6 months or even a longer period like 12 months or something, but it should still go through a court, I think. And also another reason that someone might not be detained beyond 72 hours is maybe they petitioned for the 14-day hold and it got rejected by a judge because the judge found that they weren't a danger to themselves or others, and they were still detained for 72 hours. And according to this, they would still lose their right for 6 months, and that seems unfair, although there might be times when it's appropriate to say, well, maybe they don't need to be detained for 14 days, but they should still not have guns for 6 months. So maybe that's an option that should be given to judges. So there might be other things that you could do, but I still think that they should have their day in court, and that's my thoughts. Thank you for hearing my testimony.
Thank you very much. Please proceed.
Good morning, Chair Peterson, members of the committee. Eric Nelson, I'm an Assistant Attorney General. I'm here to offer the Attorney General's Office's support for Senate Bill 5181. I am the author of, or co-author of several white papers that address access to firearms and mental health. In our last 2016 white paper, we did suggest this policy concept as one that the legislature might consider. It's modeled on a California statute, and that statute imposes a 5-year bar on possession of a firearm following their temporary mental health detention. And that statute has been found constitutional by the California appellate courts. This bill imposes a 6-month bar. It's imposed only if the detention is for likelihood of serious harm. And it enables the individual to seek restoration from a court immediately, short of that 6 months if they so choose. Therefore, it is relatively narrowly tailored and provides some due process protections, albeit after the fact that the firearm suspension goes into effect. From a policy perspective, I do think it has the potential to reduce risk of suicide, and it also has the potential to reduce risk of violence to others. In our first 2007 white paper, we noted an incident in Clallam County where a sheriff's deputy was killed by a man who had several 72-hour detentions, but no subsequent court-ordered detentions that would have taken his firearms away. And there were articles about that incident in the newspaper, and quite a bit of frustration by the law enforcement community that there was no legal mechanism to remove firearms from that individual.
Out of curiosity, what was the time period that elapsed between the most recent 72-hour hold and when the incident happened?
Ooh, I don't know, Senator Peterson. This event occurred in August of 2000. I was looking this morning to see if I could find the newspaper articles on the web about that incident, and I don't have that kind of detail. But Senator Solomon, you asked a question in regards to whether this bill has sufficient nexus, and I would point out that the firearms bar in this bill only occurs if the person is detained for likelihood of serious harm. So there are two bases for detention. There can be grave disability, which is an inability of a person to care for their own essential needs of health and safety, essentially not taking care of oneself, or likelihood of serious harm. And that can be harm to self, harm to others, harm to property, or threats to others' physical safety and a history of one or more violent acts. So I think there is a reasonable nexus between a danger to self or others and the suspension of firearm rights for at least up to 6 months.
And you've spurred a follow-up question from Senator Solomon.
So my understanding of the 72-hour hold, it's sort of an emergency detention before a judicial finding, and then if that person is released from a 72-hour hold, it by definition means a court has found that they're not a serious harm or not gravely disabled. Is that correct?
Well, not necessarily. They
haven't met that burden.
The DCR could just make a determination that the person is cleared within the 72 hours, and then a petition is never if a petition is never filed, or if one has been filed, it could be withdrawn. And so
I missed one of the words you said. So if their symptoms abate, then they're not necessarily going to be subject to a petition.
That's correct.
Okay. So by definition, there isn't a finding by a judge under a 72-hour hold.
That is correct.
Thank you.
Senator Holy has a question.
Well, thank you, Mr. Chair. It's kind of set a stage here a little bit under 5205 we talked about a couple of minutes ago. If we could define violent acts, that almost has a compelling enough basis up there that I'd consider that. I look at something like this, and Senator Solomon, I'm kind of following his thought. I noticed that you referred to California issues there, which is great if we're talking about the federal Constitution, Second Amendment issues. I actually understand that there's greater protections under Article 1, Section 24 of the state constitution that says that the right to private possession of firearms shall not be impaired, which is diminished in value or reduced on that. That's a little bit higher bar to overcome here. So I'm not talking about Second Amendment issues out there and the derivatives of Heller over the period of years. Again, I'm going to pull rank in this forum, and I'm going to say that everybody else here, they're talking about this in an academic or philosophical setting. I'm a retired police officer, and there's a vast number of people that I've placed at 8 North and Sacred Heart for 72-hour evaluations. It is a triage mechanism is what it is. A lot of people that were placed there might have been for anything as wide a variety as a diabetic response all the way to an LSD trip kind of a thing that which would follow the community caretaking function that sometimes this process. Not everybody's held for a complete 72 hours. Sometimes the people are processed rather shortly in the first 8 hours, for example, when mental health comes in and actually does the evaluation, and they're released at that time. So the mechanic is something like this. As soon as you're involuntarily placed for an evaluation, is not a definitive finding by any means at all. And I think that the intersection you're talking about, Senator Solomon, here is probably the process without the lack of due process completely, a review of something that would be a triage measure that's not definitive by itself and practical application over a period of years of doing something like this and seeing the people that were processed back out. So I would have a little hesitancy myself here, not because everybody in the panels hasn't provided an extremely compelling case to do good on something like this. But again, we swear to uphold the Constitution, and you have a foundational laws out there. Unless we overcome the inherent protections, within the law, that are provided out there, the foundations that are personal protections. In Article 1, Section 1 of the state constitution is pretty clear about the purpose of government in Washington state is to protect and maintain individual liberties. I want to make that clear that this is something I think we have a hard time following Senator Solomon's lead on this, that would be overcoming.
Don't you agree? Did you have any further comments?
I really don't. I'm not prepared to really do a thorough constitutional analysis or a gun wall analysis that would distinguish state constitutional rights from federal constitutional rights. I mean, this is something we will potentially have to work out in the courts if the legislation is passed.
All right, Senator Patton.
Well, the legislature in recent years has taken some significant action to try to prevent suicides, and a lot of that's been led by Dr. Jennifer Struber with Forefront at the University of Washington. Did you contact her about this legislation? I mean, they're not here to testify. I haven't received anything from them, and yet I know she's very committed to working on these issues, but she also is committed to working with people that support the Second Amendment or support the state constitution. So have you worked with her or with Forefront on this bill?
Senator Patton, I do know Dr. Stuber. I've met her before. I did not have the opportunity to talk with her in advance about this bill.
All right. Thank you.
Okay. Any other questions for this panel? All right. Thank you very much for coming forward. We have one final panel, Zoe Moore, Martin Reinsel, and Mike Nelson.
Good morning to everybody. Hope you're all right and everybody's well. My name is Zoe Moore. I'm a Mom Demand Action in the 37th District in Seattle. I'm here for the 5181 and also for the 5205. My daughter, Dana Harvey, died. She's a suicide. She was a mental person. She died January the 10th, 9 days after my birthday, New Year's Day. And I'm here to let you know that if that was in effect, this bill that was in effect, the 72-hour hold, I think she would be alive today. It would have helped her. I would have had time to get some help for her and have her committed into the mental hospital or wherever the help would come from. She would have been living, I think so. And I'm just here to let you know that she was 27 years old, 99 pounds. She shot herself in the head with a .38 firearm. I tried everything as a mother to help my child to live. But the mental illness was so demanding and overtook her, the schizophrenic, that I had to call Seattle police officers to pick my child up out the street 3 times when she would run out of my apartment. And I'm here to ask you guys to just feel what I'm feeling in my spirit and in my heart, that this should be on the bill, this should be on the table, both of those bills. There's no doubt in my mind that she wouldn't have been able to be able to be on trial for anything because of who she was as a mental ill person. And also she was able, this would have prevented her from getting a gun permit from the state, but she got a gun permit. And she was being seen up under mental health for 5 years. And she still was able, she never had a criminal record or none of that. She was just she wasn't qualified to live a normal life, if there is any such thing as a normal life, before what's going on today. But I'm just asking you, she would not have been able to stand trial for any of it, because you would see the predicament that she was in just by looking at her. And as a mother, that right there makes me wonder of how the system is set up to help mental illness. It's mental illness. I was seeking mental health for the mental illness. That's what that means to me. Seeking the help to get mental illness, some kind of information on it, some way to stabilize her. I was reaching out to all type of people. Just when Leanne said, once you shoot yourself in the head, that's it. There's nothing you can do. But I am here to let you know that I am standing for the moms, the men, that's as a mother first of anything, and to help our children, your children, my children, all your children. They are my children, and my children are yours. And I need to let that be known that this would have saved my daughter's life if these two bills get on the table or out of this building, however you guys set it up, or whatever you do. Just finding your heart to look at a mother, to see her child, bled out after I enter into her apartment, to do whatever I had to do for her, to see where my child bled out. And that's devastating for any mother to see, your baby's blood, just wasted. And the help, and for me, just to seek the help that I needed, I was powerless, and I just could not help her. But this right here saved some babies' lives. If you put these ballots on the table, I'll say yes, yes. And let us not rush and rush and rush and be anxious, because every time we rush and rush, we miss the mark. We miss the mark, and we miss our blessings. Because children are precious. Life is precious. So keep that in our hearts. Agape love to everybody.
Thank you very much for sharing your story. Please proceed.
My name is Martin David Reinsel. I'm a licensed mental health counselor in the state of Washington. I'm a constituent of the 34th District as well. I work in highly acute psychiatric settings. I have over a quarter-century experience professionally and specifically over 2 decades working in highly acute crisis intervention locations, including the involuntary psychiatric hospitals in West Seattle. We see over 1,000 patients every year in this hospital. The vast majority are brought in under 71.05. With the 72-hour hold, they're a danger to self, danger to others, and we see people that are at this nexus of a very, very vulnerable and fragile point in their life, and this bill is so important with regards to public safety, obviously reducing suicidality, but also the greater good of the community. We see people coming in that have decreased insight and impaired judgment, and that does not clear up in 72 hours. And a lot of times, we see people get to go through court, and it is outside of the hospital's medical recommendations by our treatment teams to discharge someone, but the person can slip through. And if you don't mind, I'd like to cite something that just happened last week. We had somebody that was discharged from our hospital by the court against medical advice of the treatment team. And just so people understand, the treatment team is doctors, nurses, social workers, peer support counselors, et cetera, that are involved in this process. And this individual was granted release after a motion to dismiss the case was filed by the defense, since the patient had not been seen in the time frame legally allotted by the DCR. As was noted earlier, they have certain time limits, 6 hours or 12 hours. In this case, the members of the treatment team hope that this individual does not hurt someone in the community. We have no way of ensuring this, since he was released from our locked facility on a technicality. Again, this is an issue of public safety. Someone who is a risk to harming themselves or others during a time of great psychological fragility should seemingly not have access to a firearm during this time of crisis. It is that simple. Medications to stabilize take 4 to 6 weeks. We often see this go beyond hospitalization in general, even on a 14-day. So please know this period of fragility often expands long before and long after any court might decide to discharge someone. Thank you.
Thank you very much. Please proceed.
Thank you, Mr. Chairman and members of the committee. My name is Mike Nelson, and I'm a council member for the City of Edmonds. I'm here to speak in support of Senate Bill 5181. On January 5th of this year, and our Edmonds waterfront was bustling with activity, with families out walking for a lunchtime stroll, when a 56-year-old man walked over to his sister in a parking lot and shot her in front of her 12-year-old son before shooting himself and taking his own life. This is just one example of the tragedies our communities are facing with violent acts by people who are suicidal. The problem is that this small portion of people with mental illnesses who are dangerous usually do not seek treatment on their own before they do something harmful. So when someone is being involuntarily held for 72 hours in a mental health facility because they are considered a danger to themselves or others, we should heed this warning. We know from research that people who have been hospitalized involuntarily for this short period are at an elevated risk of violence to themselves or others, that a short-term involuntary hospitalization is, quote, meaningful and reliable indicator of an individual's dangerousness, unquote. We know from research that the risk of allowing these type of individuals with serious mental illness access to guns can be just as dangerous as arming violent criminals. The good news is laws that reduce access to firearms by adding time and distance between firearms and high-risk individuals during high-risk periods can prevent gun violence. This law balances protecting public safety by temporarily prohibiting dangerous people from accessing guns while preserving their fundamental right by timely restoring their firearm access when they are no longer dangerous. Please support this evidence-based law because it will save lives. Thank you.
Thank you very much. Do we have any questions for this panel? All right, looks like you're free to go. That'll conclude our public hearing on Senate Bill 5181. We'll move to a hearing on Senate Bill 5399. And Tim, if you could give the briefing.
Good morning, Chair, members of the committee. Tim Ford, staff with the committee, and before you is proposed Senate Bill 5399. It's on pink paper, and it's an act relating to child relocation by a person with a joint decision-making authority and equal residential time. The proposed sub actually changes that title so that the title would be the new title would be an act relating to a child relocation by a person with substantially equal residential time. By way of background, the Child Relocation Act sets forth a process by which a custodial parent, although we don't call it custodial anymore, the laws have changed now to a parent with whom the child resides a majority of the time. That parent has a presumptive right under law to move the children. Notice is required, and it must be given to those who are entitled to visitation or residential time, and a person may object to the relocation within 30 days. Otherwise, the relocation is permitted. If there is an objection, then the court will hold a hearing, and the court does not apply a best interest of the child test. What it applies are statutory factors. These are factors, about 10 or 11 of them, that are set forth in law, and if the court weighs all of these factors, no factor is given greater weight than any other factor, and the person who is objecting has the burden to show that the relocation would be detrimental and outweighs the benefit to the child. And they look at all kinds of things: the child's relationship with the parents, siblings, prior agreements, whether it would be disruptive, and additional contacts. I won't repeat them all, but they're set forth in the bill report. So that is for parenting plans where one parent has the child a majority of time. There are other parenting plans where there's either a 50-50 split or substantially equal time is designated in the parenting plan. And for those types of parenting plans, there was a 2017 appellate case in the marriage of Ruff and Worthley, and the court in that case found that the Child Relocation Act does not apply for 50-50 parenting plans. And so what the court does is it applies the best interests of the child test under a different law, not the Child Relocation Act. And it looks at the existing residential plan under that law, and it retains that plan unless a substantial change has occurred in the circumstances of the child or the non-moving party on the basis of facts that were unknown to the court when the plan was established, and relocation is in the best interest of the child. So what this bill does before you, besides the title change, it changes the Child Relocation Act so that it applies to all parenting plans, 50-50, substantially equal, and plans where the parent has the child a majority of the time. Substantial equally residential time is defined, and it includes arrangements in which 45% or more of the child's residential time is spent with each parent, and that is determined based on the designated time in the court order, unless there's a substantial deviation that's agreed to by the parents. So the presumption no longer applies for substantially equal plans, and the court makes a determination in the best interest of the child, considering the statutory factors that are set forth in the Child Relocation Act. And there's no fiscal note.
Thank you. Do we have any questions for staff? All right. Thanks very much, Tim, for the briefing. I will say only that we had a work session about this issue up in Bellingham in September, and there is this narrow class of cases that unfortunately has grown more substantial as 50-50 plans have become more prevalent. And we've had some really difficult circumstances that we have placed some of our citizens in who have dissolved their marriages, have kids and parenting plans, and then life intervenes and one of them needs or wants to move. So the fact that we don't have a relocation act that can apply to those circumstances and folks have no opportunity to get back to court has presented some really substantial challenges. To hear firsthand about that, let's just go ahead and bring up Ethan Burchison, who spoke at our work session and inspired the legislation. And since we last spoke, has had a case decided in the Court of Appeals for Division I. Welcome. Please proceed.
Thank you very much for inviting me for this opportunity to speak and share my story. I'm here to support SB 5399 to fix the Child Relocation Act. As you pointed out, I recently, on about a month ago, received the Division I Court of Appeals decision on my case, which actually expanded the previously mentioned decision to say that it doesn't matter what parents agree to. There's no way that they can move. So I'm the father of an 8-year-old son, and I share joint custody with his mother. We don't actually split time 50-50. Because we don't follow our parenting plan exactly, I have my son about 60% of the time, but that isn't relevant based on case law. I'm also remarried, and my new wife lives in Maryland for the last 1.5 years due to a mandatory work assignment. For the past 2 years, we've all been caught in the middle of an ongoing legal quagmire as the courts have debated whether a single unclear sentence in the law overrides the agreement that we wrote into our parenting plan years ago, which allowed us to relocate. This has been an unending period of uncertainty and emotional stress for everyone, not to mention a perpetual financial crisis. Years ago, my son's mother and I agreed on a parenting plan. Generally, we've been able to agree on big picture issues, and so we agreed to split custody evenly. We also both agreed that we wanted the right to relocate in the future. We were aware that the law had created challenges for 50-50 parents in relocating, so we clearly wrote that into the parenting plan. Because neither of us were from Washington. We'd met in New York, we didn't have any family roots here, we don't own property here, and we both wanted to have the option to move somewhere more affordable than Seattle in the future. So our parenting plan includes a clearly stated agreement that both of us have the right to start the relocation process. We knew the status quo can't stay the same forever, and so that was our way of planning ahead to create a clear and straightforward process to resolve future disputes quickly and affordably. So I mentioned that I've remarried. My current wife has been living in Maryland for the last year and a half. When we met, she was a student at the University of Washington Medical School. She graduated in 2017, and she received a mandatory 5-year assignment to work at the University of Maryland. Doctors don't really have a choice in this. They have to do it. So after my wife received her assignment, my son's mother and I tried to come to an agreement on how to handle the situation, but ultimately the problem was just too big for us to work out on our own. So we went forward with the process we'd written into our parenting plan and asked the courts to help us decide. But the timing was just horrible because a couple weeks after my wife received her residency assignment, this new court case came out, changed the case law, found that 50-50 parenting plans don't apply. The Child Relocation Act doesn't apply to 50-50 parenting plans. So when our hearing day came, the judge said that the court had no authority to reach a decision. We never had a trial or any other form of due process. None of the evidence was considered. It just was tossed out. I want to clarify something. The judge, the Court of Appeals, was very clear to say this was not a best interest of the child process. The judge said several times that it was just simply the new case law forced him to dismiss the case, even though he had concerns about the consequences it would have for our son. Again, we thought we'd written a crystal clear instructions to avoid this kind of conflict. But the Court of Appeals decision has said it doesn't matter what we put in our parenting plan. It doesn't matter what's in the best interest of the child. It doesn't matter the reasons why we want to move. There's simply no possible scenario in which a parent with joint custody will be allowed to move simply because the construction of the law takes away our legal authority as parents to make our own agreements. The financial consequences of this have been just devastating to all of us. It's a combination of the staggering legal bills plus just the cost of being stuck living in a very expensive city in Seattle. My wife and I have to rent houses on both coasts now, so we've had to take out loans. Our debt's now growing by about $2,000 a month. My son's mother's also having a really tough time keeping up with Seattle's rising cost of living and rent. She can no longer afford to rent a 2-bedroom house. She's now living in a single bedroom, sharing a bed with my 8-year-old son. This has been a no-win situation. We're barely hanging on as we're forced to continue living in a city we can't afford that we didn't envision residing in long term. And my son's just placed in the middle of all of this. He's being put in a much worse position than he ever would have been if the courts had simply reached a decision and we could have moved on. You know, while it would be nice to live in a world where the status quo never changed, that's simply not a realistic policy to build our laws around. I'm sure that any parent can relate to the fact that sometimes life events happen which make it impossible to continue on with the status quo. Nearly a quarter of the state's parenting plans have 50-50 residential schedules. Many of these include relocation agreements, which are now meaningless. It is not fair to prevent parents like us from deciding how we want to handle difficult choices without the kind of choices that have no easy answers, and to say we want to decide that in a clear and straightforward way. Healthy families need freedom and flexibility to agree on what is best for themselves. The current law is not providing solutions. It is just preventing families from moving forward with our lives. It's not preserving harmony. It's just prolonging these conflicts. It does not serve the best interests of children. It prevents judges from considering the facts at all and forces the court to dismiss all 50-50 relocation cases regardless of the consequences. This is not right, and I cannot imagine this is what the legislature ever intended. It doesn't appear to be what the legislative records indicate was the legislature's intention. So please, act now to fix the law. Make it so that if a parent with a joint custody needs to relocate, then judges will treat these cases neutrally and be able to make fair decisions which fully consider the child's needs and protects the quality of the children's lives. Thank you again for your time and for giving me this opportunity to share my story.
Thank you very much for sharing your story and bringing the issue forward for us. Any questions? Thank you. Okay, we'll now bring up Rick Bartholomew, Patrick Ronsley, and David Ward.
Good morning, Chairman Peterson and members of the committee. My name is Rick Bartholomew. I'm here representing the Domestic Relations Attorneys of Washington, which is an independent organization of family law attorneys throughout the state. And we have no affiliation with the Washington State Bar Association. I wanted to make that clear. This Senate Bill 5399 fixes a hole that's in the current Relocation Act. I think the previous speaker adequately explained that, but his situation is not unique at all. And what I like about this bill, I think what's really important, is this bill takes the best interests of the child into consideration. And it now gives people, such as the previous speaker, an opportunity to come before the court. Now, the court may still determine, no, the child shouldn't relocate, but at least he could present his facts, and a judge could determine what is best for this particular child. The bill has been adequately explained, and I just wanted to point out that our organization does emphatically support this bill, but I don't have any really further comments to make, except also to say if other issues in the bill come up, our organization is happy to work with the sponsors to work any of those out, if there may be any. Thank you.
Thank you very much. Senator Patton has a question.
Thank you for your testimony and coming up to Bellingham, and also thank you for talking to Spokane attorney David Krause. I understood you had a conversation for whatever, half hour, 45 minutes. Mr. Krause was all set to testify today, and he got called to trial, so he may send some written stuff, but I know he had a conversation with you. He indicated he still had some concerns about the bill. Is there anything you can relate about that?
His concerns primarily were that if there were 50-50 parenting plans, then obviously both parents are, at least they consider each other fit parents, or this wouldn't have happened. And he felt that children should just remain where they are because they're stable in their environment. And so if one parent wants to move, it wouldn't be appropriate to take that child out of that child's current environment. And so he was satisfied with leaving things as they are, to where the Relocation Act doesn't apply, and in effect requiring the person who wants to relocate to show detriment in the other person's home, which would be extremely difficult to do because there wouldn't be any detriment. Almost by definition, you're not going to agree to a 50-50 plan. And my explanation to him was that this bill takes that into consideration because it allows the court to look at the best interests of the child and look at all of those connections that he's talking about that are connections other than just to the parents. And, given that, if I were to predict, I would predict that most relocation actions under this would be denied, but there are going to be some that won't be. And the reason I say that is he was right that children do have other connections with families, or rather with other things in the community. But again, that's something that the court's going to look at and to see how do all of those connections compare to the connection with the particular parents, and is it in the best interest of the child to be separated from one or the other of the parents? So, but his primary concern was that he doesn't think people in these situations should relocate at all if possible. And of course, constitutionally, we can't prevent the parent from leaving. The question is, does the child go with the parent?
Hey, thank you very much for relating that.
Thank you. Please proceed.
Thank you, Chair Peterson and members of the committee. My name is David Ward. I'm an attorney at Legal Voice, which is an organization that works to advance and defend the rights of women in Washington State. I'm pleased to be here today to testify in support of this legislation. We have a long history with this issue from our organization. We were involved in discussions over the original drafting of the bill that passed in the year 2000, the original Relocation Act. We had also proposed a bill the year before in 1999 where we did actually anticipate that this issue would come up and that there would be a need for a process to decide whether a parent can relocate with a child when there's a 50-50 parenting plan or one that gives substantially equal time. Unfortunately, the legislation that was adopted in the year 2000 did not include a provision on that, but there was a colloquy on the Senate floor in the year 2000 between Senator Carroll and Senator Constantine, who was the sponsor of the bill. And Senator Carroll asked, what do you do in the case where there's a 50-50 parenting plan? And Senator Constantine said, the presumption in favor of relocation doesn't apply. You look at the factors that are outlined in the bill. Unfortunately, that legislative history was not necessarily consistent with the way the bill was written, and the courts have not followed the legislative intent, I think, that was expressed on the floor, because the words of the statute don't quite fit that. And I think it is important to come back and fix this problem. I think back in 2000, when the Relocation Act originally passed, 50-50 parenting plans may not have been as common as they are today. They are more common today, sometimes by agreement, sometimes that's the decision a court makes. And in those cases, there are going to be situations where parents, for a variety of reasons, economic need, inability to continue living in a very expensive city, need to care for a family member, may have very compelling needs to relocate and cannot have even a chance to get into court to relocate unless this bill is passed. So again, thank the chair for sponsoring this bill. We do think it fills a gap that is becoming noticeably more common in Washington law. I think there have been several cases over the last 2 years where this issue has come up in our courts, and we definitely could use a legislative fix. So thank you.
Thank you. A word of warning to all of us about getting the words right rather than relying on floor colloquies. All right, Mr. Ronsley.
Thank you, and good morning, Mr. Chair and members of the committee. My name is Patrick Ronsley, and I am the Legislative Liaison for the Family Law Executive Committee of the Washington State Bar Association. This testimony is presented solely on behalf of our Executive Committee of the Washington State Bar Association and does not express the views of the Washington State Bar Association nor its Board of Governors. That being said, our executive committee supports this bill, but it does have one concern it would like to express to this committee. Our concern involves what impact, if any, would non-parental child visitation orders issued under Title 26.11 RCW would have on the determination of what would constitute substantially equal residential time as between the parents under either the 45% analysis or the substantial deviation analysis.
Yeah, and so I guess thank you for that. And I had a heads up from the bar's legislative liaison that was a question. I don't think we have much experience yet with any orders actually being issued under 2611. Do you have a different?
There was one issued, I believe, in Thurston County within the last 3 weeks.
Okay. So in a case where that happens, can you help us understand, is the parenting plan actually, if there's a parenting plan in place because there's a visitation order and there had been a dissolution, is there typically an amendment to the parenting plan?
I have no idea. That case was being argued when I was in court that morning, and it somewhat nominally piqued my interest at that particular moment. I wasn't paying attention, and the lead attorney on that case is now one of our county commissioners, and so I don't have an answer to that.
Yeah, I mean, I guess I'd be curious to hear from you. You all are the ones who actually do this on the front lines. I'd be curious to hear. The bill is written in a way that the important thing is what's written in the parenting plan to begin with. You can look beyond that if there's been a substantial deviation from what was supposed to happen, according to the judge. So my assumption is that if the parents agreed to something approximating a 50-50 plan, that would be what controls whether this would apply. But on the other hand, I'm not sure, since the point of this, to think this through and appreciate your thoughts from any or all of the three of you. If we have closed this loophole, then it does seem to me to say that there's no such thing as an exception because there's no majority, no person with majority residential time. It strikes me that regardless of what an order might say about non-parental visitation, the Relocation Act is going to be available to the parties, and then the fact question for the court would just be whether there is somebody who is a primary residential parent. If the court found that there was, then that person would be entitled to a presumption. If the court found that there was not, then that person would not be entitled to a presumption. Right? So I think that's how it would work out. And therefore, I think the conclusion that I draw is that there's not really a need for us to adjust the bill. But if you have a different view, I welcome thoughts about that.
Well, I wouldn't say that our committee had a different view necessarily. We were concerned that if you had a situation where you had two parents that if you calculated the amount of residential time, they each had 40% of the child's available time, and then a non-parent having a visitation order that would equate to 20% of that child's residential time, neither parent could ever have that 45% to get there under the terms of the statute. That was our concern.
And I guess off the top of my head, it seems quite unlikely that somebody would have that amount of visitation time, but 20% that's a healthy chunk.
If I could speak, just this would require an amendment, but a simple fix would be simply to say that the 45% threshold is as between the parents, regardless of third-party visitors, and that would resolve the question.
Okay, Senator Patton.
Yes, Mr. Bartholomew, do you think there's going to be more litigation as a result of this? And nobody's going to really want 50-50. They're going to want to have the upper hand so that they have the advantage if there is a relocation later.
Will there be more litigation? In a way, yes, because now there's going to be a resolution, whereas attorneys now can tell parents if they come in with an equal amount of time and want to relocate, you tell them, hey, we can't do that. That's what the law is. But at least this gives them a remedy. So that addition to litigation is actually a good thing. In terms of whether parents are going to have a dispute or refuse to agree to 50-50 plans, et cetera, anytime you change something in family law, that doesn't eliminate disputes. Sometimes it just moves the venue of the dispute. We already have parents who are really concerned about 50-50 parenting plans because of the relocation issue, or they want 51-49 so that if you're the 51% parent, you can move. Those disputes already exist. What this will do is just shift the line as to where those are. I don't think there's a way we can write the bill to eliminate the disputes altogether. We can only move them.
But I think you said earlier that you did acknowledge that a lot of these relocation requests, you thought the majority would be denied because of the factors that Mr. Krause was concerned about and the ties of the child to the neighborhood, the community, the school, maybe other relatives, all those things, and the disruption of moving. And whether you're in an intact family or not, I know I was in fifth grade, our family moved from Illinois to Seattle, and that was very disruptive to me, with an intact family. So.
I agree, but I don't think that it's appropriate to, I don't think the appropriate remedy is to say nobody has a right to even ask, because there are going to be cases where it's in the best interest of the child for that child to be able to move. And, the fact that we have, maybe the majority, it's not, shouldn't deprive a substantial minority of people from being able to ask the question. So I agree with, kind of the analysis, except I don't think the conclusion of let's not do this at all follows, if you understand what I'm saying.
All right. There appear to be no further questions. Thank you very much for bringing that forward. We'll put together an amendment and perhaps run it by you all. All right. That'll conclude our public hearing on Senate Bill 5399. We'll move to consideration of our final bill, Senate Bill 5450. And Tim, if you could give us a report.
Good morning, Chair, members of the committee. Tim Ford, staff with the committee. Before you, Senate Bill 5450, an act relating to Superior Court judges. And by way of background, the number of Superior Court judges for each county is set in statute. And it needs to be, when it needs to be changed at the legislature, there's a process. The Board of Judicial Administration recommends the change, and it's based on an objective analysis of judicial resources and the caseload activity of the court. Superior Court judges and commissioners hear a variety of different types of cases: felony, other criminal matters, civil matters, probate, juvenile, and appeals from administrative agencies. Our state constitution provides that the state and the county share the cost for Superior Court judges. And so a judge's benefits and 1/2 of the salary is paid for by the state, and the county pays the other half. For additional judicial positions to become effective, the legislative authority of that county must approve the position and agree to pay out of county funds and without reimbursement those expenses associated with a new position. Currently, Clark County has 10 elected Superior Court judges, and Ferry County, Pend Oreille County, and Stevens jointly have 2 elected Superior Court judges. What this bill does is that it will add a judicial position for Clark County, and for Ferry, Pend Oreille, and Stevens County would have an additional position as well. And of course, the legislative authority has to agree to pay for the expenses without compensation from the state.
Thank you very much. Any questions for Tim? All right. We have 2 folks signed in to testify, and Senator Rivers sent her regrets. Let's bring up Dory Nickpon and Scott Collier. Please proceed.
Thank you, Chair Peterson, members of the committee. We would like to express gratitude on behalf of the Board for Judicial Administration. For the record, I'm Dory Nickpon, testifying on behalf of the BJA. This legislation is brought to you as request legislation from the BJA. Staff counsel did a good job of describing the statutory scheme, and to make good on statutory obligations for the administrative office of the court, there is a workload analysis undertaken each year, and where there's a determination that certain jurisdictions have workload that would support justification for additional Superior Court judges, there's an inquiry made about whether the local jurisdiction has an interest in BJA coming forward with the legislation that would adjust the number of Superior Court judges, as is done in this bill. So we appreciate your willingness to hear the bill. I have additional information about the judicial needs estimate analysis if you need it. And we would appreciate your support for the additional positions.
Thank you very much. Please proceed.
Thank you. My name is Scott Collier. I live in the 49th Legislative District in Clark County. I'm the current presiding judge of Superior Court in Clark County. Appreciate this opportunity to come and address the committee, and wish to thank Senators Wilson and Rivers, who are the sponsors on this bill, who both happen to represent Clark County as well. This request started with that annual judicial needs study that was done. It comes out in September, and it showed us what we knew we were experiencing: an increase in caseload, matters, number of hearings per matter. I don't know exactly how the formula works. What I can say about it, it's been done by the statisticians and those that know that type of thing at AOC and BJA. What I could say is, anecdotally, we could see this increase was coming. We were actually a little taken back, because I think the year before it showed we were short 0.4 judges. And going from 0.4 to 2 being short is quite a jump in 1 year. But I think that has something to do with the growth that we're seeing in Clark County. We currently have 13.40 judicial officers, so between Superior Court judges and court commissioners. This needs assessment says we should be at 15.34, so we're short 1.94. I'm going to round it up to 2. 2 judges. Our county, as you're probably aware, is one of the fastest growing counties in the state. I checked with our planning department just at the end of last week, and in 2017, they were projecting a growth of 1.8% each year, and over a 8-year time frame of 15% growth. Checking in on that growth rate during 2017 and what they assessed for 2018, we are actually exceeding their high growth rate. So it helps explain why we took the big jump as we've talked about here. Our judicial need, because this growth is projected on, like say, another 6 years, is going to just be continuing to grow, and we're not wishing to get too far behind. We're not asking, so it's showing that we're 2 judges short. At this time, we're not asking the state legislature to approve 2 additional. We're just asking for the 1. We believe that will be adequate for us at this time. Doesn't mean we won't be back in a few years with the growth that we're expecting. I also want to assure the committee that we've taken steps that are necessary to try to prevent us from having to be here. Our last time we added a judicial position was my position 10 years ago. So we haven't been here for a while yet. We've been experiencing, Clark County has that growth. We've been taking steps to help assure that we don't need to be here. We've got 4 therapeutic courts that we run that help prevent recidivism and bringing people back in and clogging up the system. We've adopted, as the legislature has approved and made optional, the increased mandatory arbitration limits. We've adopted those to the max so we can try to move those cases that qualify under mandatory arbitration out to be handled in a different way. Our county adopted a local rule 40 a couple years ago, and we're seeing the benefits of that. Let me briefly explain that. It made us as judges to take a more active role in managing our litigation, moving cases through the system faster, so we have the lowest number in there clogging up. And even with doing that, we still see these judicial needs assessments coming out. You know, I can't tell you that it's broken today. I can tell you it's on the way to getting broken. And we're concerned that if we don't move on it this year and with the growth that we're having, by the time we're able to get it fixed, it will be broken. One of the things I think this is important is the judicial needs survey takes a look at across the state, whether mathematicians and statisticians challenge the algorithm that they use and where it may be a little bit flawed. It's comparing us to all other counties across the state under the same model. And so you have a good comparison. Counties like us that fall behind, it becomes an access to justice issue. So that if you're in Clark County, it may take longer to get in and get your matters heard than if you're in another county in the state. This being a state court system, we should be held at parity with other counties, and this would help assist that. The cases that are really going to get hurt are many of the types that you're hearing about today, the family law cases, the real estate cases, the insurance claims. The criminal cases have the constitutional mandate that we need to handle those. They take priority. And there are certain civil matters like parent termination of parental rights that we have to prioritize. But those cases that are going to really get the short shrift as we get clogged up are the civil cases, which are frequently the citizens, you know, that have the greatest need. They are people that come to the courts with an expectation, and we might be put in a position where we aren't able to really meet that. So we're asking for your support today on this Senate bill. They'll help us move forward and not get behind.
Thank you very much. Senator Patton has a question.
Yeah, just a couple of questions. Do you have the support of the Clark County Council and Executive for this request?
A qualified support, and let me explain what that means. We have a new county executive that just got hired on. We just got a new county chair. We've been meeting with them on budget. They have indicated to us that they're very supportive, but they have not pledged that if you pass this, they are immediately going to do the other funding. I also serve on a jail committee. We're looking at building anywhere depending upon the $200 to $300 million new jail facility because we haven't had a jail for 40 plus years. Part of that is looking into and building additional court space and do it. So what they're saying right now is they're taking a look at it. We have what they're calling a deep dive on our budget, Superior Court budget, coming up in the next couple of months. So the county executive and new county chair have indicated their support, and they believe in our judicial branch in Clark County, but they have not formally yet said they've budgetarily passed it. They're optimistic about being able to do that, but they have not formally done so.
I think they are optimistic being able to do that this legislative session. I mean, normally in the past, that's been a requirement for the legislature to act that way. I mean, we want to make sure, not always, but normally we want to make sure if we're going to do something that there's the local support to cover their
Correct.
The costs.
I can't guarantee that at this point, but they are lending their support, but they're not officially saying if this is passed, they're going to fund it immediately. They do give the impression it'd be funded in short order. We're in the middle we've switched from a 2-year budget cycle to a 1-year budget cycle. So we've already passed the budget for 2019, and we're starting on that process for 2020. That's probably where it would get addressed. However, there is law and justice issues that they're planning on taking a look at, this being one of them, in the latter part of the year with some potential budget adjustments, such as creating an Office of Public Defense as opposed to independent contractor system for the public defense, as well as this. So this is on the books, on the table to be looked at and studied. But it might be 2020, which isn't far away.
No. Do you have efficiencies in cooperation with Clark County District Court? Do the district court judges, I know in Spokane sometimes will do first appearances. And my other question is, are your warrants shared by district and Superior Court, or do you guys do all the warrants, and are those handled electronically now, or what?
We share a number of things. Warrant duty is one thing that we share. I would say that district court handles more of our initial warrants, which makes sense. That way, if I'm reviewing a warrant and the constitutionality of it, I'm not reviewing my benchmate just right down the hall. But we both share in that. We share a number of things like jury administration, court interpreter administration. They review some of our district court or our Superior Court domestic violence protection order petitions. They've done that for years. So there's a number of things where we work together. We share our pretrial release program that we're taking a look at creating reform in, which is a hot topic, I know, with the legislatures as well. So the answer to that is yes.
And then one final question. Do you or does District Court in Clark County have any satellite offices, say in Battleground or Camas or Washougal or any other place to even do on the District Court side? In Spokane County we do and do mitigation dockets and things like that.
Superior Court has the main courthouse. We have a family law annex, which is just a few blocks away, but it's not in the same building. District Court operates under contract to Camas Washougal District Court. Battleground has their own district court. Our district court does the city of Ridgefield as well. So their satellite office in Battleground, their satellite office out in Camas Washougal for district court. We do not have a place.
Thank you very much.
All right, seeing no further questions, that'll conclude our public hearing. Thank you for coming forward. Oh, I'm sorry. The other part, I just wanted to mention that. Oh, Senator Patton wants to mention that we all received a letter from the
right, I just
Stevens
didn't want
County.
us to, on the record of not mention the request from Ferry, Ponderay, and Stevens County, which is tri-county, and from Judge Jessica Reeves requesting support for the bill for that area to get an additional judge also.
A little easier for me to travel up I-5 than for them to come over.
Okay, thank you very much. That'll conclude our public hearing on Senate Bill 5450 and conclude our work for the day. We are adjourned.